This is Title 9 under the New Civil Code under the Provisions of Partnership, Chapter 2, The Obligations of the Partners. Section 1, Obligations of the Partners among themselves. Article 1784. A partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. That is Article 1784. Article 1785. When a partnership for a fixed term or particular undertaking is continued after the termination of such term or particular undertaking without any express agreement, the rights and duties of the partners remain the same as they were at such termination, so far as is consistent with the partnership at will. A continuation of the business by the partners or such of them as habitually acted therein during the term without any settlement or liquidation of the partnership affairs is prima facie evidence of a continuation of the partnership. That is Article 1785. Article 1786. Every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. He shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed to the partnership, in the same cases and in the same manner as the vendor is bound with respect to the vendee. He shall also be liable for the fruits thereof from the time they should have been delivered without the need of any demand. That is Article 1786. Article 1787. When the capital or a part thereof which a partner is bound to contribute consists of goods, their appraisal must be made in the manner prescribed in the contract of partnership, and in the absence of stipulation, it shall be made by experts chosen by the partners, and according to current prices, the subsequent changes thereof being for account of the partnership. That is Article 1787. Article 1788. A partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor for the interest and damages from the time he should have complied with his obligation. The same rule applies to any amount he may have taken from the partnership coffers, and his liability shall begin from the time he converted the amount to his own use. That is Article 1788. Article 1789. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision, with the right to damages in either case. That is Article 1789. Article 1790. Unless there is a stipulation to the contrary, the partner shall contribute equal shares to the capital of the partnership. That is Article 1790. Article 1791. If there is no agreement to the contrary, in case of an imminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital, except an industrial partner, to save the venture, shall be obliged to sell his interest to the other partners. That is Article 1791. Article 1792. If a partner authorized to manage collects a demandable sum which was owed to him in his own name from a person who owed the partnership another sum also demandable, the sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may have given a receipt for his own credit only. But, should he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. The provisions of this article are understood to be without prejudice to the right granted to the other debtor by Article 1252, but only if the personal credit of the partner should be more onerous to him. That is Article 1792. Article 1793. A partner who has received, in whole or in part, his share of a partnership credit, when the other partners have not collected theirs, shall be obliged, if the debtor should thereafter become insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only. That is Article 1793. Article 1794. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen this responsibility if, through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. That is Article 1794. Article 1795. The risk of specific and determinate things which are not fungible contributed to the partnership so that only their use and fruits may be for the common benefit shall be borne by the partner who owns them. If the things contributed are fungible or cannot be kept without deteriorating, or if they were contributed to be sold, the risks shall be borne by the partnership. In the absence of stipulation, the risk of the things brought and appraised in the inventory shall also be borne by the partnership, and in such case, the claim shall be limited to the value at which they were appraised. That is Article 1795. Article 1796. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership and for the corresponding interests. From the time the expenses are made, it shall also answer to each partner for the obligations he may have contracted in good faith in the interest of the partnership business and for risks in consequence of its management. That is Article 1796. Article 1797. The losses and profits shall be distributed in conformity with the agreement. If only the share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. In the absence of any stipulation, the share of each partner in the profits and losses shall be in proportion to what he may have contributed, but the industrial partner shall not be liable for the losses. As for the profits, the industrial partner shall receive such share as may be just and equitable under the circumstances. If besides his services he has also contributed capital, he shall also receive a share in the profits in proportion to his capital. That is Article 1797. Article 1798. If the partners have agreed to entrust to a third person the designation of the share of each one of the profits and losses, such designation may be impugned only when it is manifestly unequitable. In no case may a partner who has begun to execute the decision of a third person, or who is not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of such decision. The designation of losses and profits cannot be entrusted to one of the partners. That is Article 1798. Article 1799. A stipulation which excludes one or more partners from any share in the profits or losses is void. That is Article 1799. Article 1800. The partner who has been appointed manager in the Articles of Partnership may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith, and his power is irrevocable without just or lawful cause. The vote of the partners representing the controlling interest shall be necessary for such a revocation of power. A power granted after the partnership has been constituted may be revoked at any time. That is Article 1800. Article 1801. If 2 or more of the partners have been entrusted with the management of the partnership without specification of their respective duties, or without a stipulation that one of them shall not act without the consent of all the others, each one may separately execute all acts of administration, but if any of them should oppose the acts of the others, the decision of the majority shall prevail. In case of a tie, the matter shall be decided by the partners owning the controlling interest. That is Article 1801. Article 1802. In case it should have been stipulated that none of the managing partners shall act without the consent of the others, the concurrence of all shall be necessary for the validity of the acts. And the absence or disability of any one of them cannot be alleged unless there is imminent danger of grave or irreparable injury to the partnership. That is Article 1802. Article 1803. When the manner of management has not been agreed upon, the following rules shall be observed. 1803(1). All the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership without prejudice to the provisions of Article 1801. That is 1803(1). 1803(2). None of the partners may, without the consent of the others, make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. But if the refusal of consent by the other partners is manifestly prejudicial to the interest of the partnership, the court's intervention may be sought. That is Article 1803. Article 1804. Every partner may associate another person with him in his share, but the associate shall not be admitted into the partnership without the consent of all other partners, even if the partner having an associate should be a manager. That is Article 1804. Article 1805. The partnership books shall be kept subject to any agreement between the partners at the principal place of business of the partnership, and every partner shall at any reasonable hour have access to and may inspect and copy any of them. That is Article 1805. Article 1806. Partners shall render on demand true and full information of all things affecting the partnership to any partner or the legal representative of any deceased partner or of any partner under legal disability. That is Article 1806. Article 1807. Every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. That is Article 1807. Article 1808. The capitalist partners cannot engage for their own account in any operation which is of the same kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transactions, and shall personally bear all the losses. That is Article 1808. Article 1809. Any partner shall have the right to a formal account as to the partnership affairs. 1809(1). If he is wrongfully excluded from the partnership business or possession of its property by his co-partners. 1809(2). If the right exists under the terms of any agreement. 1809(3), as provided by Article 1807, and 1809(4), whenever other circumstances render it just and reasonable. That is Article 1809. Section 2, under Chapter 2, Obligations of Partners, Section 2 is the property rights of a partner. Article 1810, the property rights of a partner are 1810(1), his rights in specific partnership property, 1810(2), his interest in the partnership, and 1810(3), his right to participate in the management. That is Article 1810. Article 1811. A partner is co-owner with his partners of specific partnership property. The incidents of this co-ownership are such that 1811(1), a partner subject to the provisions of this title and to any agreement between the partners has an equal right with his partners to possess specific partnership property for partnership purposes, but he has no right to possess such property for any other purpose without the consent of his partners. 1811(2), a partner's right in specific partnership property is not assignable except in connection with the assignment of rights of all the partners in the same property. 1811(3), a partner's right in specific partnership property is not subject to attachment or execution except on a claim against the partnership. When partnership property is attached for a partnership debt, the partners, or any of them, or the representatives of a deceased partner, cannot claim any right under the homestead or exemption laws. And 1811(4), a partner's right in specific partnership property is not subject to legal support under Article 219. That is Article 1811. Article 1812. A partner's interest in the partnership is his share of the profits and surplus. That is Article 1812. Article 1813. A conveyance by a partner of his whole interest in the partnership does not of itself dissolve the partnership, or, as against the other partners in the absence of agreement, entitle the assignee, during the continuance of the partnership, to interfere in the management or administration of the partnership business or affairs, or to require any information or account of partnership transactions, or to inspect the partnership books, but it merely entitles the assignee to receive in accordance with his contract the profits to which the assigning partner would otherwise be entitled. However, in cases of fraud in the management of the partnership, the assignee may avail himself of the usual remedies. In case of a dissolution of the partnership, the assignee is entitled to receive his assigner's interest and may require an account from the date only of the last account agreed to by all the partners. That is Article 1813. Article 1814. Without prejudice to the preferred rights of partnership creditors under Article 1827, on due application to a competent court by any judgment creditor of a partner, the court which entered the judgment, or any other court, may charge the interest of the debtor partner with payment of the unsatisfied amount of such judgment debt with interest thereon, and may then or later appoint a receiver of his share of the profits, and of any other money due or to fall due to him in respect of the partnership, and make all other orders, directions, accounts, and inquiries which the debtor partner might have had, or which the circumstances of the case may require. The interest charged may be redeemed at any time before foreclosure, or in case of a sale being directed by the court, may be purchased without thereby causing a dissolution. 1. With separate property by any one or more of the partners, or 2. With partnership property by any one or more of the partners with the consent of all the partners whose interests are not so charged or sold. Nothing in this title shall be held to deprive a partner of his right, if any, under the exception laws as regards his interest in the partnership. That is Article 1814.